I understand the next call is a split call. I'll call Andrew Little.
That's great. Thank you, Mr Speaker. It's a pleasure to take and stand a call on this bill. So the thing is this, family law is, as we know, one of the most difficult areas of legal practice. It's not like a commercial dispute where the parties might have some money or an asset at stake. It's not like an employment dispute where somebody's feelings might be hurt or their dignity might be attacked, but it can be assuaged through reinstatement or through compensatory payment. Family disputes go to the heart of who we are. And when family disputes erupt, people have a huge emotional interest at stake, and they have offspring to consider, often a family home, and memories, and all those things that go with it. These are very difficult disputes. And so we need to have in place an institution, a court, a family court and family institutions that will help parties of all types get through their disputes. It's interesting reading the regulatory impact statement, their analysis of the figures. They say about 39% of the family court's time at the moment is taken up with parental disputes. That would be about right. And because they don't have accurate figures on how many disputes actually are fractious and difficult and disputatious, they extrapolate from the English experience and say that about 10% of family disputes go to court and about 12% of those go on to a hearing. That's what we're talking about. So all this nonsense about how, we'll just let the parties sort it out themselves, the parties who are capable of sorting out their disputes themselves are already doing so. And they don't need to be patronised any further by an uncaring, unknowing government that doesn't know what it's doing, that has brought this ill-thought law to Parliament because it actually doesn't know what's going on. And we don't need to be patronised either. But what we do need to make sure, if this government is genuinely concerned about the children whose interests and livelihoods are at stake, is that they have a means to get their interests properly and independently advocated, and that they have an institution that will nurse parents who will be experiencing all sorts of levels of difficulty through a very difficult period. And it will require professional reports and advice, and they will require their own advocates. And some will be difficult, and some will be accommodating, and we need a system that can deal with all shapes and manner of those disputes. And so the reason why we are opposed to this legislation is that this is nothing other than a cost-saving device. This idea that fractious families will go off and sort it out themselves with the benefit of a mediator without professional advice, without professional reports, is just cloud cuckoo land stuff. And it will do more damage to young people, to children, and it will do more damage to the litigants, and it's just something that we should not and cannot tolerate if we are serious about the state playing its useful and constructive role and representing the public interest in family breakdown. And if any political party should know about the impact and consequences of serious family breakdown, I would have thought it would be the National Party, because they are a party where even the party president has had to suffer the experience of the family court and family breakdown. And the idea that now that they will be assisting families, and particularly the children of families in breakdown, with a $1,000 or more cost and fee is just absolute nonsense. And so we are left with no option but to oppose the bill, because it is not about reforming the family disputes procedures. It is about putting up barriers, and it will not assist those families in breakdown in a period of significant need. So it is presumptuous of the bill, as it says it presumes that families can sort out these disputes themselves. It is presumptuous to do so. Families have to make the judgment. Individual parental parties have to make the judgment about when they need assistance, when they need advocacy, and the court must be in a position to afford and to accord representation to children at this time, when they are at their most vulnerable, and when no one is thinking rationally, when everybody is driven by emotions and a sense of loss and grievance. And that is when they need the most support, and the family court system must be able to do that. And so the idea of limiting access to legal advice and support is just plainly ridiculous. So for that reason and for those reasons, we will be opposing this bill.
I call David Clendon. 5-minute call.
Thank you, Mr. Speaker. This is an important piece of legislation.